Good morning, everybody. Good morning and welcome. Welcome to the Senate Committee on Judiciary and Public Safety. Thank you, Madam Clerk. At this time, I would like to hear from Representative Chairman Graham Filler from the House of Representatives. Chairman Filler, please take the testimonial table. And Rep. LeGrand, is he here? Rep. LeGrand, welcome. Good to see you guys. More importantly, today, members, is a presentation and overview of the expungement package that came across from the House of Representatives. The chairman, as well as Representative LeGrand, were champions of the package, and we are going to have just an overview, and I'm going to limit the speakers because there is a lot of them to some time after you guys present the overview. So welcome, Chairman Filler, and welcome, Representative LeGrand. The platform is yours.
Thank you, Chair, and thank you, Committee. And I'm going to do 5 minutes, and then David's going to clean up, play cleanup hitter. And so I'm going to give you just 3 things today, which is how we got here with the expungement package, what the bills do broadly, and the House process. And so I'm a first-term rep. Many reps or senators who are representatives have been working on this for a number of years. And I'll just tell you, I think there's a lot of power behind expungement. And I think people see the same thing as I did, which one of the best ways to help people with criminal records get jobs, get access to loans, get access to housing, help people be productive members of the community, increase safety in a community by lowering the chances of recidivism. And all I did, really, as the House Judiciary Chair, was take work by Rep. LeGrand and Democrat reps and House reps, put those bills together, bills that I thought would be instant impact, and quarterback them through the House. So I'll just tell you that after we did press conferences in Detroit and Kalamazoo on expungement, we received essentially 3 weeks in my office of positive phone calls to the office about people who felt like this was going to help them get jobs, help them take off in life. And I don't think I have to tell you how rare it is in this business to receive 3 weeks of positive phone calls. So I do believe in the power behind this. Let me just tell you broadly what the bills do, what expungement bills do. Broadly, they expand eligibility to access expungement, not just for high level or low level, but for all kinds of crimes that you can get on your record. It's very proportional. Don't you think it's odd that under our current expungement law, you can ask a judge to take a very serious felony off your record, but you can't ask for the lowest level traffic offense to be taken off your record? Our bill package fixes that with the Rep. Pauline Wenzel bill. There's a marijuana bill that makes it easier for individuals to get their marijuana misdemeanors expunged and really recognizes our society's changing views on marijuana. There's an automatic bill that says specific low-level, non-assaultive crimes after you've been cleaned from the justice system. So remember, expungement is only for the good actors, people who've moved on, can be wiped away. And a quick aside here, philosophically, is there anything in conservative or liberal political theory that demands an individual's criminal record follow them for the rest of their life? I don't think there is. We would say you pay the proportional price for your action, and then we want you to move on, we want you to succeed, we want you to be in your community. And so that's, broadly speaking, what the package does. And then finally, I want to talk to you about the work done in the House by Rep. LeGrand and many stakeholders and myself. We worked very closely, and I think you're going to see on the House analysis 53 organizations, that's cities, that's business organizations, think tanks, law enforcement, that do support this bill package, and I think it speaks to the work we did. We worked with the Michigan Chamber on changes dealing with financial crimes. We worked with the prosecutors on crimes not allowed to be automatically expunged. We worked with the Michigan Attorney General's office and Representative Robinson on an improved marijuana bill that would make it easier for you to apply and easier for the prosecutors to oppose if they so choose so. And so what did we learn, broadly speaking? The package in front of you is the product of compromise and knowing that if this becomes law, Michigan will become a national leader in expungement reform, in freeing up people's individual liberties, and giving people better opportunities to work. So thanks to Rep. LeGrand, Rep. Gay Dagnago, Rep. Robbie, Rep. Wenzel, Rep. Meerman, Rep. Lloydhäuser, and of course, Representative Robinson too. Thank you to the stakeholders for their painstaking attention to details in the House, and thank you to the committee for considering this package. Rep. LeGrand.
Thank you. So first of all, I want to thank all of you because we've all been engaged in conversations about this long before this, and just so the public knows, we really started thinking about this, Chairman Filler and I, last January, not this January. So my joke was how I spent my summer vacation last summer. Well, Chairman Filler and I really were just hammering details of this out pretty much all last summer. And so he's absolutely right, and I can't emphasize enough how much this is the byproduct of a lot of, and he said compromise, I'd almost say careful thought. So let me just give you one example. Some of you know I was a prosecutor. I started my career in the Kent County Prosecutor's Office. And I sort of think, what I'm concerned about in public safety terms is, that bad person out there who we really want to keep track of, and that person who's dangerous or a real concern for public safety. And so one of the things that we did fairly late in the game on this bill package is introduce, and I want to, if you want to take a note, it's in Bill, whatever it is, 84, on page 2. So whatever these start with, 4984. We put in what I call the fool me once provision, which is to say, when we're talking about expanding expungement, what I don't want, and I don't think any of us want, is say somebody who commits an embezzlement when they're 25, and then they get it expunged when they're 35. And then they go out and commit another embezzlement, and they get that one expunged. And then they go out and commit another embezzlement, and they get that one expunged. So we specifically put a provision in here that says you can only get one, if you've done the same exact crime, you only get one bite at that apple. You don't get to get 2 embezzlements expunged, even though embezzlement's a non-violent crime, or like writing a bad check. If you've done that, you don't get to do that over and over and over again and get your record expunged over and over and over again. So there's been a lot of careful thought here into how do we sort out the people who really justify our having faith in them, that they're going to go out in the community and do good stuff. And forgive me if I sound like a Republican, but I don't like big government. I don't like government intrusion in people's lives. The less the government can be involved in people's lives, generally, the better. This bill package does a lot of us a lot of us come here because we have a heart for the poor. We have a heart for people who need to get a leg up. And how sometimes some people talk about that as having the desire to help people, help themselves out of poverty. This bill package, if we enact it, is going to be more effective than Michigan Works for the families that it impacts, with no government involvement. This is not a government program. This doesn't involve a bunch of oversight and babysitting. This is not a nanny state bill. This is the opposite. This is letting people who we have good data shows that they are no more risk to the general public than the general public. They are no more at risk than a member of the general population. Those folks, if we can get them back in the workforce, there's all kinds of data that shows there's really, other than empathy and classes for thinking for change or something like that, there's basically 3 ways to lower people's risk: education, age, and getting a job. I can't make people older with a bill package. This is not an education package, but this is a jobs package. And getting people back into the workforce is one of the foundational ways that we make the community safer. We also make people simply wealthier, and that's huge given the concerns we have about poverty in our community and the effects that poverty has on people's behavior. So I just want to emphasize that. And the only other thing I'll say, and we're happy to answer questions. As you can tell, we've been working on this for a long time. First of all, thank you, Chairman Lucido, for the Senate changes. They're all improvements. So we can go into those in details if you want, but they're great. So thank you for engagement on this and for the Senate subs. We've looked them over. They're great ideas, and I want to thank the head of SCAO, now ex-Judge Tom Boyd, who did a lot of granular work on trying to make this a better and easier program to implement and something that's going to be less costly. And he can speak to that. I don't know if he's going to speak this week or next week, but I'll leave that to him. The last thing I want to point out is that fundamentally we're talking about two things here. One is things you can go to a judge and ask to get off your record. That, by definition, it's okay if that's a bigger group of things because a judge is listening to you and saying either yes or no. So the automatic portion of this is by design much more narrowly tailored than the application part of this process. Because if something happens automatically, a judge isn't looking at it, you got to be a lot more careful about it. And that's why Chairman Filler pointed out we don't have assault, we don't have violent crimes in that category. It's a narrower category. It's later in time. So you can go, right now you can go and apply for expungement after 5 years. Automatic in our package doesn't happen for 10. So it's a much longer wait for things to happen automatically. Again, that's a product of compromise, discussion, and again, I want to maybe not correct, but at least Chairman Filler said something about he worked, with me and Democrats on this, and I'm sure that was a misstatement because I'll tell you, I mean, I can list, my colleagues in the House. Tommy Brand cares about this issue. Brana Colley is really concerned about this issue and engaged. Luke Meerman. I mean, I could list the people who have the most robust, good, heartening conversations I've had about this. It's probably split 60-40 Republican-Democrat, to be honest. Maybe I shouldn't have said that out loud. But there's been a real bipartisan engagement on this, and I really appreciate all of your engagement on this to this point. Thank you.
Thank you both. And you know what? I truly do appreciate all the work that was done and the meetings that you held over in the Mackinac room with all the stakeholders. It was a long journey, but you guys have seemed to have accomplished the means to the end, which is we all are practitioners. We're all lawyers. We all knew that there was a statute in place to allow expungement, so the legislature talked already many years ago. They gave a 5-year window. If you had one conviction, you were allowed to go ask a judge to expunge it. This is nothing new. As time went on, and I had the pleasure of working with Chairman at the time, Kesto, in the Judiciary, we expanded that to a couple misdemeanors, a couple felonies, nonviolent, those type of things. And I kept thinking to myself, if I'm 50, 60, 70 years old and I had committed a crime at 18, why is this thing got to haunt me? And what is the purpose of it? What was the impetus of allowing it to continue when we already had expungement package? We already had the ability to do something. And then talking to stakeholders, as we're going to do now, we've learned an awful lot. So I wanted to tell you, we appreciate all the work that the House has done. It was just minor cleanups, but things that we thought might enhance the benefit for those citizens that we serve. Thank you for being so honest, Representative LeGrand. You truly were a champion from the beginning of time with the stakeholders and Judge Boyd to bring about a result that is going to be something that we are going to be looked at as leaders and cutting edge law in this state. So thank you. We have a lot of people to speak. I don't want to be curt, or I don't want to be what's called limited on your time, but the fact is we have a Senate, we have to go to session. So I'm going to start off giving everybody 3 to 4 minutes and seeing if we can get through this. I know Senator Barrett, you have a comment before we start off with all of the speakers.
No, I can withhold my questions till the appropriate time, if that's today or a different day, Mr. Chair.
And Senator Irwin, I know you do too, but if we could just get to these.
I just wanted to thank Representative Filler and Representative LeGrand because I know at a certain point here we're going to get into the meat of this over the course of the next couple of weeks, and there's going to be conversations about details. I just want to start off by saying I really appreciate the work they did in the House in getting it to this point.
Good job, guys. Thank you very much. Okay, let's start off with Sharon Dietrich, Community Legal Services of Philadelphia's Employment Unit, to speak. Sharon, good morning and welcome to committee. Can you hear us?
Good morning. Can you hear me?
We sure can.
Excellent. Thank you for having me this morning. I'm speaking to you from the town of Hamburg, Pennsylvania. I am the litigation director at Community Legal Services in Philadelphia. And the reason that I, of all people, was brought before your committee today is to talk about Clean Slate as we have experienced it here in Pennsylvania. I'm one of the originators of the concept, and I was one of the primary advocates who worked on the bill in Pennsylvania, the first state to pass Clean Slate, and then later the implementation, which we're about to come to the end of it later this month of June. I have basically 3 things I would like to do with my time, and I'll try to get through them as quickly as I can. The first is to talk about why we developed and supported this Clean Slate concept. Professor Starr will talk more about the numbers behind it. I want to talk a bit about the people behind it. Secondly, I want to talk to you about the results that we've achieved in Pennsylvania since we started implementing the bill almost a year ago. And finally, I want to talk about how Michigan can be a leader in this space. So first of all, the very abridged version of why Clean Slate. So I've been a legal aid lawyer, employment lawyer for low-income workers in Philadelphia my entire career, which has been 32 years. And when I started my job, we did not think about criminal records. That was not an issue in the employment law space. But for at least the last 25 to 30 years, we have seen an increase in the extent to which our clients need mitigation of their criminal records in order to be able to work. And by that I mean criminal records has become the single most common reason low-income Philadelphians seek employment law help in Philadelphia, and I dare say that's true around the country. And in my experience of representing literally thousands of people with criminal records, I can tell you that there is no record so old or so minor that it can be counted on not to present a barrier. If you've got a case on your record, chances are it's going to haunt you. I represented one woman who was rejected from a job because of the summary offense of disorderly conduct making a loud noise. I've represented many people who have not even convictions on their record, but just non-convictions, and were turned down by employers based on that. So because of the barrier that criminal records present, expungement became the mainstay of our representation in my legal aid program in Philadelphia. And we are very well resourced, we're very experienced, and we set out to do as many expungement petitions as we could. And every year we'd manage to do more. We'd think of new innovations so that we could do more. For instance, we came up with a document assembly program that prepared the petitions for us, thousands more than the year before. But no matter how hard we worked to keep things going, to do more and more, we did not even begin to touch either the need for this service in our community or the number of cases that were eligible under Pennsylvania law to be expunged or sealed. So we came up with the idea of Clean Slate, the idea that technology could do the work to clear the records, and it has been universally popular in Pennsylvania. The bill had enormous bipartisan support. Our lead sponsor was Senator Scott Wagner, who was the Republican challenger to Tom Wolf in the last gubernatorial campaign. Republicans on both chambers strongly supported the bill. There were only 2 votes against it in the 2 chambers combined. The Pennsylvania Chamber was one of the biggest supporters. They saw it as a way to bring a whole new workforce unencumbered by any potential liability. The Pennsylvania DA's Association supported the bill. Americans for Prosperity PA supported the bill. When we get together to do some acknowledgement of an important moment in implementation of the bill, everybody wants to be on the stage. Now, if I had more time, I could talk about how we designed this, how we determined that it would be feasible, how we've implemented it, but I know that we don't. So let me move quickly to what the results have been. As of the end of April, 34+ million cases have been sealed by the automation in Pennsylvania. And more than 950,000 Pennsylvanians have been helped by this bill. Let's focus for a minute on misdemeanor convictions. we only started sealing misdemeanor convictions in Pennsylvania in 2016. Our eligibility standards are far behind yours. But in the time that we have had the ability to petition for misdemeanor convictions to be sealed, only 1,500 have been sealed. By contrast, Clean Slate has automatically sealed over 85,000 of them. And let's also focus on what automation has meant during the pandemic. The courts in Pennsylvania have been closed, as well as most of those around the country, and consequently, processing of expungements and sealing petitions around the country is basically ground to a standstill. In Pennsylvania, in March and April, because of Clean Slate, 3.8 million cases were sealed. Finally, let me talk about how Michigan can lead on Clean Slate. So, felony convictions are not eligible to be sealed in either Pennsylvania or Utah, the two states that have passed Clean Slate bills so far. And therefore, we don't have felonies as part of our Clean Slate models. Although I believe that's going to change in Pennsylvania. We're going to get felonies to be sealable, and we're going to bring them within Clean Slate. But Michigan can make Clean Slate and its model even more impactful than in our other states by applying it to felonies. And in doing so, you are simply deciding that cases you've already deemed eligible for being set aside will in fact be cleared. And you will allow millions of Michiganders and their families to move on with their lives. I'm happy to entertain questions, but I commend you for taking up this legislation, and I'm happy to be of any help in the future with respect to Pennsylvania's experiences.
Thank you very much. We appreciate your testimony and your time this morning. Members, is there any questions? See none. Thank you very much, and enjoy your day. Next, we're going to hear from. We're going to invite Gracie Berger to speak. Is Gracie there? She's going to come via Zoom. Gracie? Gracie, are you on with us? How about Sonia? Sonia, are you on? Sonia Starr.
I'm on, yeah.
Good morning, Sonia. Can we limit the testimony for about 3 to 4 minutes because we've got a lot of speakers, okay?
I will do my best.
You're on, Sonia. Welcome to committee.
Thanks for having me. I'm a law professor at the University of Michigan, and along with J.J. Prescott, who's also here, I've just completed a major study of criminal record set-asides in Michigan. Set-asides, by the way, that's the Michigan label we use for expungement. That's what I'll use too. Our study's findings strongly support the expansion of Michigan's set-aside law. They include good news and bad news. The good news is that people who got set-asides have great outcomes in terms of both crime and employment, which is great for their families and for the general public. The bad news is that currently those great outcomes are not reaching many people because very few people actually get set-asides. I'm going to start with a few details on that bad news point. As you know, the legal requirements for set-asides are very strict, and most people with records in Michigan don't qualify for them. But beyond that, we found that even out of those who do meet the requirements, only 6.5% actually receive them within 5 years of becoming eligible. And we project that less than 12% of those who legally qualify will ever receive set-asides in their lifetimes. So why is that? It's not primarily a problem of judges saying no. Michigan judges are actually very supportive of set-asides. Once people have proven themselves by not committing another crime for years, most judges support giving them a second chance, and they grant about 75% of applications that they receive. But the problem is overwhelmingly people aren't applying. And why would that be, given the burdens of a criminal record that Sharon outlined? Well, one is lack of information. Most people who are eligible don't know it, and they don't have lawyers to advise them. But two, even those who do know are daunted by the incredibly demanding process. There's tons of bureaucratic hoops to jump through. There's multiple trips to court, going to the police station, making and notarizing, mailing lots of copies of forms. You got to take time off work. You got got to get childcare. There's a non-waivable fee. There's lots of costs for fingerprinting, notaries, copying, mailing, requesting the certified record, the cost of transportation. And most of these people are living in poverty, so that all really adds up. And so, in short, I think that the petition-based process is so burdensome that even if the eligibility rules were much more generous, very few people would benefit from it. So I think the most important of the many great bills that you're going to be considering is the Clean Slate bill that requires automatic clearance of some records. If we want people to get access to set-asides, there's no reason we should mire the process in endless red tape, and automation is the simplest and best solution. Now, to the good news from our study, we should want to expand access to set-asides because the outcomes for people who get them are great. For one thing, set-aside recipients have incredibly low subsequent crime rates. In the 5 years after getting a set-aside, only 7% of recipients had been rearrested for any crime, and only 4% have been reconvicted for any crime. And among those that were rearrested or reconvicted, it was overwhelmingly for nonviolent misdemeanors. Only 1% of set-aside recipients are convicted of any felony within the next 5 years, and only 0.6% are convicted of any violent crime, including violent misdemeanors. So those numbers, of course, aren't zero, but if you follow any group of tens of thousands of people for 5 years, you're also not going to get zero arrests or zero convictions. There's some crime in the general population, right? And it turns out that the crime rates among set-aside recipients are actually lower than average for the population of Michigan. That is, set-aside recipients are not only less likely than most people with records to commit crimes, they're less likely than most people, period, to commit crimes. So why are their crime rates so low? We can't tell directly from our data, but we could take guidance from a much broader body of research on the factors predicting crime. One factor is that those who obtain set-asides are probably very low risk to begin with. And the main reason for that is that they've all satisfied the 5-year waiting period with no subsequent crimes. And many studies show that after just a few clean years, it's pretty safe to assume that a person is done committing crimes. And our study indicates that 5 years is plenty for this to be so. Were it up to me, by the way, I would reduce the automatic bill waiting period to 5 years. 10 years is certainly very conservative. If someone's going to reoffend, it's highly likely it'll be in the first year after conviction, and it really drops off steeply over the next couple of years. So beyond their initial low risk, it's also quite likely that receiving set-asides lowered this group's crime rate even further, because access to employment and stable housing and education all help people to avoid committing more crimes. So if a set-aside helps people to get jobs and rent apartments and get admitted to schools, that's good news for crime control. And I think we should think about expanded set-aside access as a public safety measure and not as a public safety risk. And that brings us to the second piece of great news from our study, which is that set-asides do provide a pathway to employment. Set-aside recipients saw, on average, about a 23% increase in wages within the first year after the set-aside. And overwhelmingly, that's not just because they're getting higher paid jobs. It's because they're getting jobs in the first place. Unemployed people are finding work. People who are just working a few hours a week are finding more stable jobs. So 23%, that is actually a huge gain. That kind of improvement is far greater than what we see in programs like job training. And programs like job training, states invest thousands of dollars per person in. So if you want to get people with records into the taxpayer base, into the workforce, off of unemployment, which are all great things fiscally for the state, expungement appears to be a very cost-effective strategy for doing so. And that'd be even more true if expungement were automated, because that's much cheaper per person than the petition-based process is. So I think this is a very cost-effective way to improve the employment prospects of a lot of Michigan residents, also improve, we think, likely their access to housing, education, and all of that will help to make Michigan safer. So thanks very much for having me here and for taking on this really important issue.
Thank you very much, Sonia. I have Ms. Starr, I do have a couple questions real briefly. Number one, how long was this survey done where you talked about the 23% employment? Was in a period of years? How many years did you run this survey?
We studied. We studied everybody who received set-asides over the course of it was about a 12-year period. But then they get the improvement. The improvement kicks in about during the first year, and after the first year, it basically stabilizes. So they don't lose those gains, but by about 1 year after the set-aside, those gains begin to kind of plateau, like once they basically entered the workforce.
And how many individuals, Ms. Starr, were there that you surveyed by number?
So our study, in total, we studied all 30,000 or so people with records who had received them by the time we received our data in 2014. But the number that we had the years of wage data for, I think it was about 20,000 that we were able to include in the employment part of our study. I can't remember the exact number, but it was basically everyone who received a set-aside with in Michigan over the period in question. And we're really grateful to the Michigan State Police and to the Unemployment Insurance Agency for making the data we needed available.
Right, I knew that there was some barriers for receiving data. It was very difficult. The way our system is, we don't have a comprehensive system that talks to each other, let's just say, from the court system through the lien, and somehow it's a disconnect. We got to spend money to update the system. Lastly, you try to explain to members, and I want them to be aware and sensitive, that when you have to do a set-aside or an expungement, you have to file a petition with the court. And these are the barriers that I think Ms. Starr was speaking of. You have to serve notice to not only the FBI, state police, the sheriff's department, but also the local community in which the crime was committed. Prosecutor's office. So you've got 5 services that have to be done. Everybody has an opportunity to object. The prosecutor ultimately will hold a hearing. It generally will take 3 to 5 weeks before you're allowed to get a hearing, because there's a background record check from the lien that shows whether or not you've had any activity in this state. Sometimes the FBI picks it up out of state. And at the end of the day, the 5-year rule had to be complied with, which it took over 5 years before you were even eligible to make the application. These barriers that were put up, I heard your testimony, and I agree with you. A lot of times people don't have a vehicle. Better yet, they don't have any opportunity to go spend it on a lawyer unless there's a clinic, a free legal clinic that will do this, and there's a few. Like Wayne State University, I think U of M also has it also. So I applaud the fact that you've done a study so that there's comprehensive data, and that's why I asked how many people were surveyed and for how long, and 23% have met the means of getting some kind of employment as a result. Any other members have any other questions? Seeing none, thank you for your testimony, and have a great day. I now invite J.J. Prescott from the University of Michigan. He's a professor. Is he with us today?
I am. I'm here. Can you hear me, Senator?
We can hear you perfectly. Mr. Prescott, thank you for joining us. Welcome to the committee, and go ahead and start your testimony.
Great. Thank you, Senator and committee members. I'm a law and economics professor at the University of Michigan, and my research and writing focus on criminal reentry and expungement-related issues. I am here to express my views on the likely fiscal requirements, which, Chairman, you just mentioned, of the automatic expungement bill. I've worked with Sonia Starr on research related to the consequences, but here I'm actually going to talk about something different, which I think you're clearly interested in hearing something about. So my opinions on the fiscal requirements are based on my experience over many years working with the data that is relevant to the set-aside process and the kinds of technology that would be necessary to implement HB 4980 if it became law. The new automated process would not require any action on the part of an eligible individual. Instead, it would simply operate within the state of Michigan's existing data systems by running algorithms and doing other types of checks to identify people whose records are ready to be expunged. So let me say something a little bit before I state my opinion, giving you a little bit of background on why I know a little bit more about what to expect here. So in addition to working with large data sets, including criminal history records and court records and other criminal justice data, in 2014, I founded the University of Michigan's Online Court Project, which ultimately led to the creation of an online platform called Matterhorn. I'm not sure if any of the committee members have heard of Matterhorn, but it is today used in a large number, actually dozens, of Michigan courts to resolve outstanding civil infractions, warrants, family disputes, small claims lawsuits, arranging payment plans for court debt, et cetera. And this is all done online. In fact, this technology is actually available to most, if not all, of Michigan citizens in some form today through Michigan's newly released MI Resolve. This software, and I'm not here to pat myself on the back about Matterhorn. I just want to try to give you guys a sense of something that I think will wind up looking quite similar in terms of the technological and data needs for expungement. It allows people outside to access the courts and to address their legal issues remotely by bringing them together with other parties, judges, prosecutors, clerks, police officers, and so on. Matterhorn, in fact, can operate like an online court. So the reason why this is relevant is that the platform shares many operational attributes with automated record clearing programs. Specifically, like any automatic set-aside approach, Matterhorn integrates with Michigan's centralized state court data repositories, as well as with the individual court case management systems, and also, in case it matters, with the Secretary of State data systems and so on. The software is easily configurable at the court level, and it offers different processes by courts, and actually by the background of the litigant and by the type of legal matter. It also moves information between agencies, courts, and individuals, and it does so in a highly secure way, as if what we're talking about here were medical records. So Matterhorn's development and scaling is now in over 80 courts and agencies and mediation centers in 13 states, has required that I and the people I've worked with many types of data, various court workflows, existing government software and hardware, and lots of institutional and legal constraints. So I have a good sense, I think, of how time-consuming and financially costly it will be to work with criminal records, build algorithms that operate on records databases, and build software that integrates information from different agencies. And while there can be little doubt that automating the clearing of eligible criminal records will require an upfront investment, it is also clear to me that automation will be an excellent investment for Michigan, both relatively and in absolute sense. So first, within a year or two of implementing the new process, the system would be far less expensive to operate than the inefficient system now operating for cases that would be eligible for automatic expungement. But perhaps even more importantly, the initial investment by the state, based on my own experience, should be quite small in the grand scheme of things, likely under $1 million, but certainly not much more if it's done correctly. So I was personally able, when I put together Matterhorn, to build a much more complicated system that interacted with multiple databases across multiple agencies and at the court level in a decentralized system like we have in Michigan with a budget of about $3 million over 4 years. And by the end of that 4 years and $3 million, the software was operating not just in Michigan and many different courts in Michigan, but actually in multiple states and helping Michigan residents resolve many different types of legal issues. So using that same set of ideas to attack the automated expungement process strikes me as actually a much simpler task than what the court system has been able to do in terms of
Mr. Prescott, we have about 1 more minute for you. I'm sorry, but that's all we have because we're ready to go to the Senate and have session. So
okay, great.
If you can
So
kind of encapsulate it, we've got one more individual that wants to speak, so please conclude the testimony.
Will do.
Thank you.
Thank you very much, Senator.
Go ahead, Tom. Senator Barrett, I apologize.
Thank you, Mr.
We
Chair.
have a question for you.
I know we're going to have time for more questions and testimony later, but the question I had for you, based on the complexity of what you're describing for a system that interfaces in the way it does, wouldn't we be able to rightfully determine if an individual has paid their restitution through a system like you're describing that has all the bells and whistles that you've said have been able to be integrated?
I mean, you know, the devil is always in the details here, but yes, if there is an agency or a court that has that record and it's in any kind of electronic form or could be easily moved into an electronic form, it should be easy to do.
Okay, thank you.
Thank you, Senator Barrett. At this time, thank you, Mr. Prescott, for your testimony. We will keep you on standby. I'm sure we're going to have more questions for you as you had put together a protocol. We'd like to learn more about that protocol. Hopefully, we can have you come in person, too, when this pandemic leaves the state. Soon, I hope. Soon, I hope. At this time, we're going to have Dan Ross in person. Mr. Ross, thank you for joining us in committee, and as you can clearly see, we are ready to leave soon to go to the Senate for session. Please, thank you, and go ahead and testify.
Absolutely, I'm ready to leave too. I wake up, I'm a felon. I have multiple felonies.
You turn your microphone on, sir.
Oh.
If it's not there already, it's the little button to the right, and you'll see a little light go red.
Better? All right.
Thank you.
Okay, so I'm a multiple felon. I have multiple felonies and misdemeanors that I got between the ages of, started at 16, but got sentenced at 17 as an adult in Michigan. From 17 to 19, I was getting in trouble, you know. After my first charge, it was like, well, forget it. You know, I'm just going to keep on getting in trouble. That was my mentality as a 17-year-old child getting out of the county doing 8 months. And I came home and I got in trouble again for illegal use of a financial transaction device. It doesn't matter if I was guilty or innocent, I got in trouble for it. And I did another year off of that. So by the time I was 19, I had came home, I had my GED, and I had the will to not want to go back to jail. You know, I didn't want to get in any more trouble anymore, and I didn't. I'm 42 years old, and it's just like I got my felonies yesterday. It's just like there's places that I can't live. There's apartment complexes that might as well not even accept my application. There are places that I can't apply for. There are businesses that I can't open. There's so many things that I can't have as a felon. There are people in my family that I can't live with because of certain services that they get from the government. You know, if they get Section 8 or something like that, you know, you got to jump through hoops in order to have a felon live with you or have a felon parole home to you. You know, if your mother's on Section 8 and you paroling home, you have nowhere else to go to, there's a problem there. The economy could be so much stronger. And I meant to start out saying about how proud I am of my state. I'm so proud of Michigan. A lot of our people outside of this building don't know what goes on, what you guys have been working on here. You know, all they know is what the media shows them. And I've been involved. I had to wait 20 years, but it ended up being 22 years because, well, 22 years to run. I ran for city council this last term. I was a write-in, if any of you heard of me, Dan Ross. We aren't bad. You know, we are you. We just got in trouble. There are many of things that this economy can benefit from allowing felons to live again, you know. There are many of us, because of the 13th Amendment, that identify as being modern-day slaves. Imagine that. Imagine identifying with being a modern-day slave here in 2020 because you have a felony. Every day, because I have more than one felony, every day I pray that I do not accidentally break someone's window and risk going to prison for the rest of my life because of it. Sounds stupid, sounds simple, but that is my reality every single day since I was 19 years old, and I'm 42. Please, please pass this bill through. We need it. We need it. It's too much discrimination. It's too much prejudice. Look outside. This is another discrimination. This is another prejudice. This is another form of racism. Get rid of it, please. That's all I have to say.
Thank you very much, Mr. Ross. Any questions of Mr. Ross? Seeing none by the members, have a great day.
Thank you.
Madam Clerk, could you read in any other cards?
Mr. Chairman, a card was submitted by Tashina Smith, representing herself in support of the expungement package, not wishing to speak. There were a couple of written testimony documents submitted that were emailed to the member offices.
Thank you. Members, you should have those, and at this time, I do not believe, unless anybody has any questions, seeing none, no further business before the Senate Committee on Judiciary and Public Safety. Stand adjourned. Thank you, members.